duly consider the notice of motion dated on 22nd of June, the supporting affidavit sworn by Polycarp Migai, and the oral testimony of the deponent together with the cross-examination and submission by counsel for the respondent in opposition of the application. The application seeks orders to detain the respondent for a period of 21 days to enable completion of an investigation into alleged offenses of arson, malicious damage to property, and assault arising from incident of 19th June 2026 during a public event in Kuresoi, North Sub-County. From the material placed before the court, the applicant contends that the respondents, jointly with others not yet arrested, participated in setting ablaze a motor vehicle and damaging other properties. However, upon cross-examination, the deponent considered the meeting in question was attended by a large crowd estimated to be between 500 to 800 persons, thereby presenting difficulty in placing specific individuals at the scene as the perpetrators. It further emerged from the evidence that the respondents were not arrested at the scene of the alleged offense, but were arrested later in the evening at a compound of the area member of parliament. The deponent was not able to state with certainty that the respondents were among those who touched the motor vehicle. This actually casts doubt on the direct linkage between the respondent and the alleged offense at this stage. The deponent also relied on an intelligence report but was unable to satisfactorily explain its content, source, or why it was not annexed to the application. The court is therefore left without any evidentiary foundation upon which to rely on the said intelligence. On the issue of flight risks, no evidence was tendered to demonstrate that the respondents were not persons of known residence or that they are likely to abscond. The mere assertion that they may abscond without more does not meet the threshold required to deny an accused person their constitutional right to liberty. Article 49(1)(h) of the Constitution guarantees an arrested person the right to be released on bond or bail on reasonable condition unless there are compelling reasons. The burden lies on the prosecution to demonstrate such reasons. This position is affirmed in the case of Republic versus Danford Kabage Mwangi, and also Republic versus Joktan Mayande and three others, where the courts emphasize that compelling reason must be real, cogent, and supported by evidence. In the present case, the applicant has not demonstrated a compelling reason to warrant the continued detention of the respondent. The evidence presented remains speculative and insufficient to justify curtailment of their liberty. The court is, however, alive to the need to strike a balance between the rights of the respondent and the interests of justice, particularly the need to facilitate the ongoing investigation. The court therefore makes the following orders. The application for detention for 21 days is hereby declined. Number 2, the respondent shall be released on bond of Kenya shillings 50,000 each with a surety of a similar amount. In the alternative, each respondent shall be released on a cash bail of Kenya shillings 20,000 plus one contact person who shall act as a surety. The respondent shall report to the investigating officer every Monday, Wednesday, and Friday until the expiry of the 21 days. The matter shall be mentioned after the lapse of the 21 days for further orders. Mention.
Wamtaka kufunga mlango ya mbele.